get the content up on the screen. Here we go. All right. Well, it's good to see everybody. Thanks for coming. I'm trying to experiment with some different ways of getting the job done. And as I go through the monologue here, if you have questions, drop them in the chat and I'll pick them up when I'm through with my monologue. I do want to recognize Umwell and Christina and Janie and Loretta, Gritty Get, John Roberts, Kestrel 42, Loretta Powell, Annette Louise, all my good folks who I've seen in other live streams. Thank you again for coming. I greatly appreciate it. As I was saying, the afternoon live streams don't seem to have as much viewership as the evening live streams, so I thought I'd do another evening live stream tonight and see if that improves at all. And I also wanted to urge any of you who are not subscribed to the channel to please subscribe. For whatever reason, I seem to have lost several dozen subscribers recently, and I'm not sure where that's coming from. I haven't done anything, particularly controversial, I didn't think, so I don't think I've lost any that way. YouTube does have this annoying trait of sometimes taking people out of your subscriptions for no good reason. People will tell me, and I thought I was subscribed, and you're not. So if that's you, please take a look and see if you're subscribed. And if you are, great. And if not, think about subscribing again. Because I really appreciate all of you watching, and subscribers matter, particularly to YouTube. So tonight, I want to talk a little bit about the value of law channels on YouTube generally, and I'd like to think this channel specifically. My aim is always to give people an understanding not only of the law, but also the strategy and the tactics being deployed by the various attorneys. I can't really say that I've seen everything in my 30 years of law practice, but I have seen a lot. And in addition to that, I worked with people who had a huge storehouse of stories about things that have gone on at trial and the crazy things that happen there. So by sort of marrying all that together, I think we can put together a pretty rounded, well-rounded explanation of what's going on in some of these cases. As weekends can be weird for law streams, that's right. Um, I've often said on this channel that the number one rule of trial law is not to annoy the judge. And the judge in Abby's case seems to have a pretty decent outlook on life. He doesn't seem to get too worked up with the lawyers. He seems to rule fairly on the objections. And I know that he's ruling fairly on the objections because I disagree with a couple of his rulings. But, that's how you know that he's playing it straight down the middle. If he gave everything to the plaintiffs, you'd have to worry about whether he was, ruling on the basis of his heart as opposed to his head. So, if that's the rule, the number one rule, the rule number two is don't annoy the jury. That means don't waste their time. That means don't insult their intelligence. That means don't play them for a fool. In order for a lawyer to have credibility, he has to get caught telling the truth at least 3 times. I don't think the defense counsel in this case are embellishing their credibility at all in the way they have treated some of the plaintiff's witnesses. And your comments, which we'll get to in a bit, are a great source of help to plaintiffs generally if they're paying attention. And I hope they are, because some of you have really hit the nail on the head in the last few days. And I want to go through some of those comments tonight on the live stream if we can. Kestrel 42, thank you. I'm glad you love the channel, and I appreciate you trying to drag friends along. So moving on, at least for now, I understand why it is that they're fighting this case so hard. I happened to catch a little bit of Vinnie Politan's talk about this case yesterday, I guess, and he indicated that Dr. Parker has been criminally charged with negligence in this case. So you can kind of see why they might be fighting really hard on the issue of negligence. Normally, when someone is charged with a crime, and there's also a civil case that gets filed, the civil case is normally stayed until the end of the criminal case. Think, for example, of O.J. Simpson's case. He was sued by the Goldmans for the loss of their son, and as a result, they had to wait until the criminal trial was over, and then they were able to get some justice, at least through although they've never collected very much of it. And in order to get a stay, in order to make the criminal case go first and the civil case go second, You have to get the judge to agree to it, and you have to get uh, you have to ask for it. The defense has to ask for it. So it says she goes on trial mid-November. It seems weird to do the civil case first. Yes, that's part of what I'm talking about here, because in the civil case, you do not have any protection if you decide to invoke the Fifth Amendment. In other words, you can't come in and say, "Well, I'm going to testify, but it has to be under a grant of immunity." No, you don't get to do that because you're testifying under oath, and it becomes information that the prosecutor can use in the criminal case. And if for whatever reason they don't ask for a continuance and the civil case goes first, well, if you testify in that civil case, it's going to come back to haunt you. Now, there's obviously an insurance company in this case. I suspect that it's part of the NEA insurance that the National Education Association has. I don't know that for sure, but pretty sure that's the case. And there's a reason why they might prefer to have the civil case tried before the criminal case. And that is if she's convicted in the criminal case, the plaintiffs can simply file a motion for summary judgment in their case. And that's because having been convicted at the level of beyond a reasonable doubt, they'd automatically be liable under the preponderance of the evidence standard. And so there's a strategic reason to try the case before the criminal trial gets done. And that's in the insurance company's best interest, but it's probably not in Dr. Parker's best interest. That's because in order to go into the civil trial and make a case for having done everything right, she'd have to testify. And since her testimony can't be immunized, no criminal lawyer in his right mind, and I realize there are a few who aren't, uh, is going to let her get away with testifying in the civil case. Because she's, like I said, no immunity. She's locked in. The testimony she's given under oath is going to come back to haunt her. Normally, the criminal defense lawyer would tell her not to testify, and he'd be pretty adamant about that. The reason would be that because if you give the prosecution in the criminal case a huge advantage, they're going to use it. But the defense in the civil case may very well be interested in having her testify and explain what she did. So there's a big tension there between the two. Sometimes what I do requires a reading of tea leaves a little bit, and normally one of the first witnesses that you would call in a case like this would be the defendant herself. The plaintiff would put her on the stand and make her account for her behavior. And sometimes that goes well, sometimes it goes poorly. But you put them on the stand and you get them on the record because then you at least have something to tell the jury about when you go to do the closing argument. Sometimes in some courts, because she's probably a hostile witness, you get to use leading questions. And again, those can be very powerful. However, even if you just had asked open ended questions, there'd still be a lot of explaining that she'd have to do. And all of that would be taken down and recorded and handed right over to the prosecutor. And more importantly, everyone in the area, the television area, would see it because several of the television stations in the area are streaming this. And it would be very hard to forget what you saw when you were in voir dire. And it might wind up causing the case to be moved to a different venue. And in some cases, for her, that might be a good thing. But the tea leaves here suggest that Ms. Parker is not going to testify. And the reason that the plaintiff did not put her on the stand is that she would have had to invoke her Fifth Amendment in front of the jury. In most states, you can't put somebody on the stand solely to make them invoke the Fifth Amendment. It's considered to be something of a denial of due process. I'm relatively certain that the defense filed pretrial motions to keep her off the stand. I would have if I'd been representing her. Certainly, the judge knows there's a pending criminal case, and ideally, the jury would not know that, but that would be the goal, to keep her off the stand and keep her from testifying. Now, not having to testify might sound like an unearned benefit, but just as there are good things that come from not testifying, there are also bad things that come from not testifying. One of those is you don't get to put your side of the story on the record. And in closing argument, the plaintiff is going to stand up and say she sat right over there and she sat through the whole trial with that smug look on her face and she kept rolling her eyes. But she didn't get up and tell you what her side of the story was. She didn't tell you how she did everything right. She didn't tell you how she didn't ignore anybody. She didn't offer you an excuse for why she thought it was better to have the mom come pick him up. That can be a very powerful way to make the invocation of the Fifth Amendment a very painful process. There's another issue at work in this case that I think needs to be explained, and that is the problem of contributory negligence. There are two systems of comparative fault in the United States. One of them is contributory negligence, the other one is comparative fault. Contributory negligence is a draconian rule. It says even if you are 1% at fault, you don't get to recover anything. And Virginia follows a pure contributory negligence rule, one of the most plaintiff unfriendly negligence doctrines in the United States, and here's how it affects the case. Under Virginia law, like I said, if the plaintiff is found to be even 1% at fault for the accident or injury, they are completely barred from recovering any damages from the defendant. Even if a jury finds the defendant 99% at fault, they're still going to walk away. The plaintiff still gets nothing. Now, you contrast this with the rule of comparative negligence states where damages are reduced by the plaintiff's percentage of fault. In Missouri, if the defendant is 95% at fault and the plaintiff is 5% at fault, and the damages are $10,000, the defendant is going to have to pay $9,500. So that's the way it works. It's reduced by the percentage of fault. In the contributory negligence scheme, the defendant has the burden of proving contributory negligence. However, Virginia does have some doctrines that can limit the impact of contributory negligence. One of them is the last clear chance doctrine, which is usually applied in the car accident case, but which could apply here. And that says if the defendant had the final opportunity to avoid the accident, the plaintiff may still recover even if they're negligent. Also, defendants' gross or reckless misconduct can override plaintiff's contributory negligence. This is the reason they've been going so hard on the issue of what Abby did or did not do. So what you'll see is they will come in and they'll ask in closing for just 1% of the fault to be apportioned to Abby. Now, the plaintiffs are surely going to counter that with lots of argument that she doesn't deserve it. I want to contrast comparative or pure contributory negligence with what I would call modified contributory negligence, which is what the state of Kansas has. In Kansas, as long as the defendant is liable for more than 50% of the fault, then the plaintiff will recover that 50% from the defendant. But let's suppose you have three defendants and one of them is not able to be brought into court, maybe because they're a foreigner or can't be served with process. If they get 75% of the fault and the defendant gets 25% of the fault, the defendant is not going to have to pay. So there are a lot of different ways that they can do this contributory negligence, and this is really draconian. The Virginia rule is very draconian. Like I said, I think the plaintiffs will probably already have developed a way to deal with that, but I just point that out there for anybody who might be interested. So I'm going to go read some of these comments because you always have good comments. Um, Amanda, thank you. Amanda, I guess that's Amanda Fence. I am sub. Thank you. I appreciate that. Loved your direct of Wendy Edelson and Charlie Edelson trial analysis. Well, thank you. She goes on trial in mid-November. We talked about that. Is this the case about the teacher and the 6-year-old? Yes, it is. Fifth Amendment, a big deal in the Karen Reed civil case. Yes, but not anymore because obviously that's gone. There's no reason to even worry about that. But in the civil case, she's now, of course, suing them, and they're going to probably, at least some of them ought to probably think about taking the Fifth Amendment. I believe the defense asked to delay the trial, but were turned down by the judge. Well, the judge has every right to manage his own calendar. And again, if he did that, I'm surprised because normally they get a little bit of grace in that regard. Smug. Yeah, I think that pretty much describes the way she acts. The defendant acts very smug. There's been some cringe in the trial. That's absolutely true. Understood. Smug isn't used enough. Agree. Um, the Melissa Perez trial, I'm going to get back to that at some point, but This one really interested me in large part because my wife was a teacher and she taught for 27 years. She has a number of opinions about this case too. As she told me, there is no way in the world that you call a principal from your classroom with the student standing right there, or a parent with the student standing right there. You have to do it away from the other students because it's a violation of privacy if you don't. So, I do try to share lots of good legal information. I appreciate you guys recognizing that. And I want to turn now, if I can, to some of the comments because I think some of the comments have just been really golden. And the case is really interesting, and people have said a lot of interesting things in the actual comments to the channel. So what I did, I went to Thunderbit. Everybody's got to have a different name. I think it's sort of like your child's first name and what you had for dinner. How they do those things with naming some of these websites. But I went to Thunderbit and I stripped the comments from a couple of videos. And this first one is from the video that I did on when Jennifer West and Amy Kovac testified. Many of you probably remember that. So the one of the first ones says, "I can hear the emotion in your voice with today's videos. Thank you for giving this story attention." I really try very hard not to get emotional when I'm doing these because I think it's a little bit unprofessional. But I really did think that lady was a hero. She went in there, the kid had a gun. He had already shot one person, ostensibly trying to kill her. He'd already shot one person, and she went around behind him and restrained him and took the gun away. And the cross-examination made her, or attempted to make her, look like she was a co-conspirator. And yeah, I think that's just awful. I like how firm the teachers are on the stand. I did too. I thought all of the teachers were really good on the stand, except that one fellow. And I thought he was way too wishy-washy. He just, he just seemed to be trying to please. It's like he's afraid he's going to lose his job if he tells the truth about what happened. And maybe he will. I don't know. Uh, they aren't letting the defense attorney walk all over him. That's true. The defendant should have tried to settle this out of court. 100% she'll be found guilty, and the jury will award a huge sum for the trauma the teacher's gone through. Well, we hope so. Seeing all that blood in the video made me shiver in fear for her. Yeah, I mean, there was a lot of blood in the videos, and she lost, I'm sure, a fair amount of blood. I thought it was really interesting when she testified what she talked about, thinking that maybe she had already gone to heaven. I really, it's one of those things where you hear that testimony and you almost don't know how to perceive it. The school needs to put their checkbook and fire this attorney. Yeah, that's right. This one I thought was really good. My heart hurts for Abby. My anger at the defendant and her counsel is palpable. She has no excuse for not immediately checking on that child. None. What if he'd shot any of those kids? The teachers were supervising multiple children. One cannot leave 6-year-olds alone on the playground or in a classroom. That's why administration is left with duties supervising children, precisely so they can handle emergencies like this one. And because the administration is testing, administration doesn't do anything on those days that requires them sitting at a desk ignoring the rest of their duties. She didn't even alert her boss. Again, all excellent thoughts. And if I were on the plaintiff's team, I'd be reading these comments and thinking, wow, I ought to incorporate some of this stuff into my closing argument. The defense does not understand how schools work. Oh, no, no, no. They understand how schools work. They want to make sure the jury doesn't understand how schools work because, believe me, they get it. They just don't want the jury to get it. Somebody said, wow, that lawyer was mean. Yeah, he was attacking the witnesses when he should be doing about fact-finding. If I was on the jury, my opinion of the defense would be very critically low based on the questioning. It would be extremely critical of their strategy. Again, strategy is a big part of doing anything with related to a trial because you're trying to, if you're on the defense, you're trying to minimize the conduct and essentially throw as much blame around as possible, but you don't put blame on the person who stopped the trauma. You don't put blame on Jennifer West and Amy Kovac. I mean, could they have called the police and brought in a SWAT team? Maybe. But the first thing that would have happened had they called the 911 is they would have called the school. And if the teacher, I mean, if the principal had not known anything about it, somebody's going to look really stupid and it's going to wind up delaying the amount of time that it takes to get help there. So, um, again, very, very good comments. I don't understand why they didn't call in SRO or police. I'm not sure they had a school resource officer, which is another issue as far as I'm concerned. Um, there is a school here in our area who not only has a SRO in uniform. He's not only a cop in uniform walking around. They also have a couple of plainclothes people walking around. And the school is locked down 24/7. You can't get in except through the main entrance, and you have to go immediately through the administration. And if you tried anything there, I think you'd probably wind up, drawing a lot of attention to yourself. So this is just one of those things where, again, if you really value what you're trying to protect, you put lots of assets around it. And they didn't apparently have an SRO. It took several minutes to get a police officer there. And you would have thought that one of the first things that principal would have done would have been called the police and had them get there. But instead, she called the kid's mom. That's just not good judgment. Um, that lady was really awesome. She seemed to understand the boy too, like Kelly Dever. Yeah, I still want to call that woman Deaver. Not because I don't know that her name is Dever, but just because I want to tweak her nose a little bit. Defense attorney tried to make it Abby. Well, I understand the approach. Wanted to make it Abby's fault because she had the first chance to deal with the issue of the gun. But you've got a kid with behavioral disorder, and you've got another teacher who's already talking to him and perhaps can get him to give up this thing. And I would certainly hope that it would be appropriate to allow her to do that. And then when she gets up and walks by and says, "I'm going to talk to Dr. Parker," then obviously Abby can't leave the classroom and go talk to Parker. Now, she could have called her, but then everybody in the classroom hears, "Hey, I think I've got a kid here with a gun." That's not a good thing. Those kids are going to jump up and run out of the room screaming the way they did after the gunshot was fired. So there are a lot of things at issue here that, I mean, I think are pretty much common sense, but apparently uh, the defense doesn't think they're common sense. Ah, so let me get up here and go to a different window. And these are some of the comments on uh, Abby Zermer's cross examination. And I thought this one was really good. I have severe spine problems. I swim a mile a day to maintain my mobility. Just because I work out and I'm in shape, that doesn't mean I don't have severe nerve damage and debilitating pain. That lawyer is a monster. Well, I couldn't agree more. I mean, that lawyer is a monster for doing what she did to Ms. Vermer. If I was on the jury, any cash settlement would have gone up. We would give this woman just went up. This poor girl truly looks shell shocked. And that's what I was trying to point out by putting those little clips in there. When you testify in court, and anybody who has had to testify about a traumatic event will tell you, you wind up having to relive it. And you don't just relive it right there on the stand. You relive it the day before, the night before, the morning before. You wake up thinking about it, then you go to court, and all of a sudden you're sitting on the stand and you are reliving it again for probably the 400th time. And anybody who thinks that it's easy to file a lawsuit and win a big bunch of cash is just dead wrong. particularly if you have to take it to trial, because it can be a very emotional experience. Now, for some reason, I have lost, there we go, the, uh, the comments here, uh, the chat. Is it unusual for discussions, arguments with the judge to be heard in front of the jury rather than sidebar? Yes, it is. And, you know, for all of the grief that I gave Judge Bev, I'm not even sure judge really belongs in front of that name, but as much grief as I gave her for just, being clairvoyant and thinking, oh, okay, yes, I know how to rule on this, even though there's no legal basis. At least she did keep a lot of information away from the jury, which was a good thing. But here, they're hearing some of these discussions and they're being told what stuff is relevant. And then when the judge says, no, that's not relevant, it can damage the plaintiff's case. It can also damage their case, make it look like they're trying to get in stuff that doesn't really apply. So it is unusual. Normally, if there's going to be an extended colloquy with lawyers, he sends the jury out. I think he expects the lawyers to be a little bit circumspect in their argumentation such that they don't, give away the whole package in front of the jury. But in some of those instances where there were significant issues, they did take them up either before trial or during the middle of trial. They'll send the jury out and then they'll talk about it in open court. Um, the teachers also had to protect the rights of the child. They couldn't just search him, and that's true because he is compelled to be in school. Every state has a law that says you've got to send your kid to school. And I mean, you can certainly homeschool them, but if you send them to school, they are compelled to be there. And they are protected by the Fourth Amendment. And you have to have probable cause in order to search a child. Now, maybe they had probable cause, but again, that's not something typically that a teacher would do. That is something that an administrator would be needing to do. Teachers really get the short end of the stick in situations like this. Yeah, they do. I mean, m- my wife has had some real interesting experiences in the hallways of high schools where people have contended that she did things. That woman ran into me. Well, fortunately, they had video, and it was pretty clear who ran into her, and it wasn't my wife. So it's good when they do have surveillance and they can look at that and say, "No, that's nonsense. You're just trying to stir the pot." Um, I call her Auntie Bev. It's the most respect I can grant her. Yeah, a lot of people have referred to her as Auntie Bev. I think I did one of those AI video songs about her, which I thought was pretty funny. Um, I felt it was bad when it was regarding the credibility of the victim. Yeah, you know, it'd be different if she didn't have scars and everything on her hand that you can plainly see. I mean, there is no question that she was shot. The only question is whether she was responsible for that or the principal was responsible for that. She had one chance to notify the principal, but she already knew that the principal was being notified. The principal had four chances to deal with this and took none of them. I think that's the point I would make. Teachers get the short end of the stick and have to pay for that stick out of their personal bank account. Isn't that true, Emily? Absolutely. Well, you're welcome for me sharing my legal knowledge. I try my best to get the information out there that I think would be helpful and useful to people. Um, that as people have noted, this is going to be a really interesting case. I'm guessing they did not have trial on Friday. I didn't see any trial posted or anything posted on court TV from anything that would have occurred on Friday. So I guess they're going to pick back up on Monday. The plaintiff's case should be pretty close to being done because they put Abby on. So I would suspect the next thing will be motions for directed verdict, which will probably be denied. And then the next thing that will be uh, on the table will be for the defense to put their case on. And they are fairly limited with putting on any friendly witness from the school. And I don't know of any that they would have, but maybe they do. they would be limited in terms of putting on um, an expert witness who could testify that the standard of care is that the teacher is always liable no matter what. Um, I can't imagine they would find somebody who would just outright lie, but there are a lot of people who can find a clever way to make the truth sound realistic. And I worry about what their expert witness would say, but then again, the plaintiff has an opportunity to rebut that, put on a rebuttal case at the end if that expert goes off the reservation, so to speak. Um, Plaintiff rested, defense witnesses were not ready until Monday, so the jury got Friday off. Well, that's a good thing. Yeah. I thought the plaintiff would probably rest. I did see that they were handling a lot of motions there at the end, but I didn't notice there was a motion to strike. I don't know how that came out. I should probably tell you, part of my routine is to get up early in the morning, and usually I have been recording the trial the day before, so I have plenty of tape to look at, and I go through that and I try to put together one or two videos. I try to get 3 videos a day in, but it doesn't always happen. And then at noon, I have other obligations. Usually on Mondays and Tuesdays, I have to go help my wife pick up kids and deliver them different places. And as a result, there's just, there's only so many hours in a day. And I feel like it's better to do quality product than to do sloppy work and, do lots of it. So I hope everybody understands. The plaintiffs were mad. Chloe, you're going to have to tell me what the plaintiffs were mad about, um, because I missed that. Um, that would be really interesting to know. Anyway, um, I have been I have been really interested in this case. I was interested in the case down in San Antonio. The problem with the San Antonio case is it's just over lawyered. There are so many lawyers in that darn case that they put on one witness for the prosecution. He lasts for 30 minutes, you know, and then you get 4 hours of cross examination by, each of the three different lawyers for the defendants. And it makes it crazy about the delay in the trial. Well, yeah, I would have been upset about that too. I think particularly when they have been very good about getting their witnesses in, getting them on the stand, asking direct questions that apply directly to the issues in the case. And then these people have just been subjected to rambling cross examinations. It has to drive them nuts. Um, they said the defense knew they would be done Thursday morning. Yeah, well, I'm sure they did know that. But again, there's probably a strategic reason. The I think probably they wanted the jury to go home over the weekend with Abby's testimony in their head, so it would be replaying in their head. Problem is, at least for the defense, that I didn't think the cross examination was really that good, and I think anybody who watched it would probably have been as put off as most of us were. So, again, strategy and tactics. I have tried cases with good defense lawyers and good, just plain good lawyers. I had a friend who's a friend now, who was who was an opposing counsel, and we just knocked each other's head in at trial. And then after that, we became fast friends. We tried other cases together. Um, these guys are not. I think they're just basically cheap defense attorneys that you get from what the way insurance companies work is they hire lawyers to defend the case, and then they limit the number of hours they can spend. They limit the hourly rate that they can charge. They limit the number of attorneys that can bill on a case. So, in a case like this where there's multiple issues, if you need to have 3 different lawyers work up 3 different issues in the case, you're going to wind up having only one lawyer do that because you're probably only going to get paid for one lawyer. So, a lot of times, probably saying more than I should, but one of the problems that we face as the plaintiffs is that defense attorneys like to bill the file. They'll they'll file all kinds of motions with really no hope of actually hitting one out of the park, but they just keep filing these motions because it looks good to the insurance company. Boy, these guys are really fighting. And really, all they're doing is, billing the case. And when the case reaches a point where they've billed as much as they think they can bill the insurance company for the defense of the case, that's when they start talking about making an offer to settle the case, if indeed they're going to settle. Normally, good cases, and I think this is a good case, normally good cases settle relatively quickly, usually within 2 years, and they settle weeks in advance of trial. Questionable cases often settle on the courthouse steps, and bad cases don't settle at all. They'd rather take it to trial and get a jury verdict, and then, they don't have to worry about it at all. This, I think, is going to be one of those cases that they wish they would have settled. That's what I think. The defense said they already said their expert wasn't coming in early. Yeah, well, of course, that's what they'd say. I've been following the Matthew Paul trial. I haven't looked at that. I'm not sure what's going on in that case. Is there any way plaintiffs can get Parker's knowledge of child's negative behavioral history out in this trial? Um, Perhaps in cross examination of any of the defense's expert witnesses, unless it has been unless it has been a subject of a motion in limine. If if they moved to keep that out for whatever reason, if the defense moved to keep that out and the judge said, no, you can't bring that in unless it becomes relevant, well, they're going to try really hard to make it not relevant. But every now and again, a witness slips up and says something about the kid's behavioral history, and they will immediately follow up. They'll draw an objection, and the judge will say, hey, your witness opened the door. So hopefully that's the way they would get that in. The dangerous history of the year prior. Yeah, one of the things that really just kind of amazed me in this case was when Amy Kovac said that when she went in there, he was sitting there with his arms crossed, looking cocky. You know, that's a learned behavior. He had to learn that from somebody. And you have to wonder who he learned that from or where he learned it. Specifically, the dangerous history. Yeah. Have you looked over the Supreme Court ruling in Mayakovsky? Yeah, I just did a video on that. I think it came out this morning. Um, I actually broke it down. It's on the channel if you want to look. The ruling is out there. I mean, it was a pretty interesting ruling from the Florida Supreme Court. Would you like me to talk about that? Just let me know. I'll be happy to talk about it. Um, the kid was comfortable firing a gun too. Yeah, somebody said, and again, I don't know whether it's accurate or not, but somebody said that the mom had taught him how to fire the gun because there had been a prior domestic incident at the house, and she wanted to make sure that her son could protect her. I don't know what mom gives a kid a 9mm handgun when they're 6 years old. I was probably 13 before I got a BB gun. I think my parents were wise to know to keep, because I am a bit of a klutz. You can ask my wife, I'm a bit of a klutz. Every time we go out to go walk or on a trail or anything, she's like, you watch what you're doing because I don't want to have any more of your bones set for you. Um, so the Maya ruling. All right. Here's the main problem with the Maya ruling for the plaintiffs. One of the reasons that you have to do really good legal research before you file a case is because you have to understand both the statutory law as well as how the statutory law has been interpreted. In pretty much every state, you are privileged to make a report of child abuse. And I used this example in the video. Uh, and that is if you are in your backyard and you happen to look over and you see your neighbor raising a hatchet and talking to his son, you might conclude from that that he was going to use that hatchet on the child. You might call the police, you might call Child Protective Services. And if you do, because you're worried about abuse, your report is immunized, at least in Florida, by the Florida statutes. Now, the report is immunized, but what happens after the report is generally not immunized if you run off and talk to the newspaper and swear on a stack of Bibles that he was getting ready to kill his kid. Well, again, um, if what he was really doing was showing him how dangerous a hatchet is, you've got a problem with defamation, all kinds of things. In this particular case, the problem for the hospital was that they not only made a report and notified the child protective team that they believed this child had Munchausen's by proxy. And as I can explain Munchausen's if anybody would like me to do that. Um, Good morning or good evening, Jim. Good to see you. I think I'm sure Peter is a great guy. Yeah, I've seen some of his stuff. Um, Last part, one of the judges making his own statement is interesting. Yes, it is. If you have the chance, read the opinion. It's available on the Second District Court of Appeals website. Um, the the main problem for them was just that they were also delivering care following a dependency court order, and that was one of the things that caused the Kowalski's problems. The issue for the Kowalskis was that the nurses and the people in the hospital, particularly that one social worker, said and did a lot of things that could very well be intentional infliction of emotional distress. Your mom's crazy. When you tell somebody that their mom is crazy and belongs in a mental institution, or when you tell the husband you need to divorce your wife, that's one of those things that can, really set people off. It can be emotionally devastating, particularly to the child. So what the court did was they threw out anything that had to do with immunity, but they kept the intentional infliction of emotional distress and some of the false imprisonment claims alive. And then, as somebody points out, in the concurrence, that judge says the reason, we're not just wiping this out completely and we're reversing and remanding because we're granting a new trial is because we believe there, at least he believed that there was absolutely outrageous conduct, and if the evidence can come in that supports that, that is not tethered to some immune conduct, and that was the problem in this case. A lot of the evidence that supported both the intentional infliction of emotional distress claims as well as the false imprisonment claims was immunized conduct because it was covered by the Florida statute. So the plaintiff has a real job of trying to put together a set of evidence that they can get in that will be not be objectionable and that an appellate court will look at and say, okay, you meet the standard. I would not want to have that job. And again, I'll say it again here. I would not have taken that case. I think that probably the plaintiff's attorneys are, they're pretty well wrapped up in it now. They've got a lot of money in this case, and they're going to have to follow it up with an appeal to the Supreme Court. If they're lucky, the Supreme Court will take it. Oh, well, thank you, Karen G. I appreciate that. Um, and if they do, then maybe they could get the judgment back. But more likely than not, they're going to have to retry the case, and it's a mess. I explained it much more cogently, I think, in my video because I had time to analyze it and put the wording of the opinion up for you to look at. Um, Well, Gritty Gret, I'm glad you stayed. I'm glad you enjoyed it, and I hope you tune in again next time. So happy to be on Alive. You are a good human being. Well, I try to be. Um, I have weaknesses like everybody else. I think the Bible says that we are all sinners. There is not one righteous, no, not even one. I certainly fall into that category, but I do my best. I try to be kind to people. I try to open doors for people. I try to mentor people when I can. Uh, you know, there is so much anger and just antipathy in the world. People who could easily just brush off an acerbic remark from someone. You see issues with road rage and all that kind of stuff. I just feel like the best way to combat that is to do just even just one kind thing a day. And I always try to do more than that. If I go into a restaurant and I get a server who brings me my food, I tell them, I very much appreciate it. You did a great job. Really enjoyed eating here tonight. Thank you so much. Because a lot of times they don't get that kind of feedback. They hear everything they did wrong, but they don't always hear everything they do right. Greg Anderson was their last hope, and now the Kowalskis fired him. 3 other law offices said no to Kowalski. Greg gave up his house and lots of things for this case. Yeah, that happens with lawyers. There are a lot of people who put pretty much everything they have into a case. That case against Johns Hopkins, that probably, I'm guessing the expenses in that case were close to $500,000, if not more. Um, Makes sense. I should have known there was more to the story than just judgment being overturned. Yeah, but at the bottom line is the judgment's overturned, but they do have a chance to go back and get it. But now they have to get lawyers who understand the distinctions, understand the evidence. There is somebody out there who will help them. I don't know who that would be, but there is somebody out there who will help them. And, I salute Greg Anderson for taking it on. I think it was a really tough case for him to make. Chloe's mom, looks like Nick will be representing Maya now. I wonder if he will be put up his house for the legal expenses. Um, I'll tell you what a lot of firms do. A lot of firms go out and get a line of credit from a bank. And one of the reasons they do that is so that they they will pay interest on that line of credit, and that becomes an expense at the end of the case that they can deduct out of the judgment or out of the payment that comes to them. And so a lot of people do it on a line of credit, but if you have to put up your house or anything like that, I don't think most lawyers are willing to do that. I think most lawyers would be far more likely to say, I really like your case, but this is not the right case for me. And I've had to do that. I've had to do that. In fact, this year, we had somebody come to us with a case, and it was, on the paper, it looked good, but at the bottom end, there's no way for the issues of proof to come through. Lawyers have to make those kind of decisions all the time, and they're not easy decisions to make. They're not comfortable decisions to make. You want to help everybody, but there are a lot more people who want your help than actually will benefit from it. So you have to be, to your own self, be true, so to speak. Um, I wish you would have watched the trial. They really did traumatize Maya, and the things they did to her were just beyond egregious. Well, it certainly comes through in the opinion. If you read the opinion, you can see that the judges were taken aback by some of the things that were said and some of the things that were done. And you know, one of the problems anytime you have someone who does what Mrs. Kowalski did, I don't want to upset YouTube here, but one of the things that she did, and that's hard to get payment for because there could be so many other potential causes. And so doing an intentional infliction of emotional distress claim was a pretty good idea. But again, they just didn't meet the elements. The conduct had to be directed at her, directly at her, in order to qualify under intentional infliction, and it just didn't. Um, I wish I would have watched the trial too because I didn't realize it was as big a deal as it obviously was. Good night. I'll be on the replay group. I'm tired. I was out late last night trick or treating with the kids. Uh, I don't think Nick put in what Greg did. Yeah, I don't know. Sarah Boone could write an ad for an attorney for their behalf. She'd love to. Sarah Boone, man, you know, Sarah Boone, I think Sarah Boone and Daryl, Daryl, the guy up in uh, Michigan, no, Wisconsin. Daryl, was it Brooks? Daryl Brooks. I mean, they're like twins. They ought to put together. She was certainly a gift to law too. I okay, that's something I missed. That the nurse told Maya that she was better off without her mom. Well, that's not the way to break the news to to a child that they've lost their mom. You know, it's kind of like the old joke about the lady who had never received a singing telegram, and she begged the man to sing her telegram to her, and so he said, "Okay, lady, if you insist." Bum 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 bum. Your sister Rose is dead. I mean, that's pretty much exactly the way it came out. And if that's what they said, you're better off without your mom. Heavens. Usually clinicians have better judgment than that. And particularly at a children's hospital, that tends to attract people who have, particularly female nurses who have that good mothering instinct. And they tend to treat those children like their own children. And they refer to them as my patient because, again, they have some ownership. Imagine a Boone and Brooks, no way she's letting his last name go first law firm. Yeah, sovereign citizen law firm. There you go. The Maya trial was horrific. Well, I'm glad in some respects then that I missed it. You know, you see enough bad things in the world as it is. The San Antonio police case is awful. The nursing profession seems to be attracting monsters lately. Some, yes, some. I have worked with a lot of really good nurses, and some of them were just absolutely outstanding. Another thing, nurse said to a coworker, not Maya herself. Okay, well that makes it a little bit better, but not completely. Um, there was a nurse that I worked with in the Midwest, and she was just one of the sweetest, nicest girls. She worked up in the intensive care unit, and she had a whirlwind romance with a young man in the city, and they wound up getting married, and they lived together for about 2 years when he developed a really aggressive and terminal case of cancer. And it was debilitating for him. I mean, he really suffered. And she turned from this kind, caring, wonderful nurse into somebody who was bitter and who just, she was unpleasant to be in the same room with. And so, again, what happens in a person's personal life can really affect the way they deal with other people. My mom used to say, whenever she would get bad service at some place, uh, my mom didn't like to fill up her own car, so she would always go to a full service gas station. And if somebody treated her badly, she would just turn to me and say, well, maybe he had burned toast for breakfast. And I thought that was a pretty interesting way of excusing bad conduct. But the more I've thought about it, it does sometimes pay to give people just a little bit of grace when they are ugly because most people don't really intend to be that way. They are usually responding to something that is absolutely not your fault, and you shouldn't have to take the blame for it. Ah, well, I have really enjoyed this tonight, folks. You guys have been a great group, but you always are. Um, and I love that. I love that about this channel. I love the people on this channel. And I also like the fact that so many of you watch this on replay. Uh, it helps me out when people do that. So, anybody have any other questions? Did anybody need me to explain how Munchausen's by proxy works, or any of that, or what Munchausen's is? Be happy to do that if anybody doesn't know. And I would also want to point out one thing. They sort of um, yeah, they did strip and take pictures of her, but that was from risk management. That's why they did that. Um, One of the things that was really I thought interesting was that in the years after she was released from Johns Hopkins, she was able to walk and run and didn't have any more relapses of CRPS, which tends to suggest, in my mind, that she really didn't have CRPS, that she might very well have had Munchausen's by proxy. And that is to the most simple explanation of that is when you create a situation where someone who you take care of, like a child, believes they are sick, acts sick, and you do it not because they're sick, really, but because you want the attention of having a sick child, which is kind of sick of its own making. Um, you're watching from, is that Great Britain? No, that's not Britain's flag. Loopy Loo. Where are you? What is the nation? I'm sorry, I don't know my flags. Sheldon Cooper would be able to tell us where that flag is from. I'm hoping for a collaboration between you and Peter, lawyer you know, on this. Well, I'm certainly open to that. I'm open to collaborating with anybody. I think one of the things that makes YouTube great is that so many people do work together and create together. I always say, we say that Australia, yes, I love Australia. There are so many things, so many animals and plants that can kill you in Australia. It's a wonder anybody survives down there, but obviously it must be a wonderful place. Uh, I like I like the fact that your news channel down there it's sometimes funny. They post it on YouTube here, and I find that to be pretty funny. Some of the stuff that they put on there. Uh, is it similar to a trauma response on the part of the child in the relationship? Yes, it is similar to that. Um, I was guessing Australia didn't want to risk it. See, you could have won the daily double. We weren't even playing that snappy little tune. I found out, by the way, that tune from Jeopardy, the da 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 da, that tune was actually written by Merv Griffin. Strange. Probably many of you don't even know who Merv Griffin is. I shouldn't have said that. I'm dating myself. When you're 71 years old, it's easy to date yourself, or 70 years old. Gosh, I don't even know how old I am today. It's been a long weekend and it's only Saturday. It's not really as lethal as portrayed. Well, that's probably true too. Media always does things to make things more than they are. I still think keeping her away from wasn't the answer. Maybe getting her mom help would have been the best option. Absolutely. And that also, even though they didn't have a doctor patient relationship with the mom, they certainly could have done more to do that. Merv created the show. Yes, he did. I've always enjoyed Jeopardy. I like beating the guys who are playing because a lot of times I do know the answer, a lot of times I don't. Anyway, I like I said, I've really enjoyed this, and wanted to make sure I hadn't missed anything. Thank you for your videos. You're welcome. Everybody is welcome. I love doing this. I love doing the live streams. I love putting out videos because it's a chance for me to give back. To give back some education about the way our system works. It makes you better informed if you go to be on a jury. It makes you better informed as a voter, and especially it makes you better informed if you vote for judges. Because if you vote for judges in your jurisdiction, you need to understand how they rule. And if you have a judicial election coming up, you should go sit in the courtrooms of the people who are on the ballot so you can see how they interact with the lawyers and how they treat people. Because not all judges are as good as the one we have in the case uh, for uh, this one, Ms. Vermer. She's that judge is pretty good, and the judge in the San Antonio case is pretty good too. Although he can't seem to keep them on any kind of timetable. I'm pretty sure that I could do 2 additional trials in the interim and still go back, and they'd still be on the plaintiff's witness, or on the prosecution's witnesses. Ah, Jennifer says she appreciates my perspectives, but really, I appreciate yours. And also, if you have thoughts about what you want to see in a video, somebody asked me to break down the Maya verdict, which is why I did, or the Maya opinion, which is why I did that. If you want something done and I can do it and I have time to do it, I will do it. So just let me know. Well, we've been going an hour now, folks, and I want to thank everybody for coming. I'm going to leave the ending soon sign up in case anybody wants to uh, talk back and forth for a few minutes. But then I think I'm going to call it an evening. And again, Jim, Chloe, Amand, Loretta, Chloe, Loopy Lou, Karen G, Emily, Christina, all you guys, thank you so much for participating tonight. And catch me on the next video, which will probably be Monday. Yes, Judge Everett was great. You are welcome. I wasn't really sure I'd be any good at this, you know. I mean, when you get right down to it. Good night. Half Proctor fallout is the gift that keeps on giving. I hope, I hope that Alan Jackson just, I hope he slaps the living snot out of those folks up there in Massachusetts. Somebody needs to teach them a lesson. Night. Thanks for the stream. You guys are welcome. Thank you. And you, everybody, have a good evening.